Committee will come to order, and without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Legislative Proposals Regarding Derivatives. I now recognize myself for 4 minutes to give an opening statement. Derivatives are financial instruments or contracts whose prices or terms of payment derive directly from the value or performance of another asset or commodity. They are primarily used to manage risk. While derivatives have long been used to manage risks related to the pricing of goods, such as produce and livestock, they have become increasingly more complex over time. Nowadays, corporations, including industrial and financial firms, use derivatives to hedge their exposure to risks, such as the changes in prices of commodities or fluctuations in currencies, interest rates, or underlying equity securities. As of June of 2017, the notional amount of outstanding over-the-counter derivatives contracts was $542 trillion with a gross market value of $13 trillion. The Securities and Exchange Commission and the Commodities Futures Trading Commission, CFTC, are the regulators charged with supervising the trading of derivatives. The regulation of the derivatives market changed drastically in response to the 2008 financial crisis. Title 7 of the Dodd-Frank Act restructured the derivatives market to more closely resemble the market for listed securities and listed futures tradings. The reforms included mandatory clearing for certain swaps and increased data disclosures meant to promote greater market liquidity and transparency. However, despite these well-intentioned reforms, Title 7 of the Dodd-Frank Act has resulted in a fragmented regulatory scheme of the derivatives market. Perhaps the largest criticism of Title VII is one outlined in the recent Treasury report on capital markets, is the lack of clarity provided to the SEC and the CFTC on how they should propose and issue their rules. Title VII bifurcated the regulatory jurisdiction over swaps. The CFTC oversees interest rate swaps, index credit default swaps, foreign exchange swaps, certain types of equity swaps, and other commodity swaps. The SEC oversees the security-based swap market. While the CFTC has finalized their swaps rule, the SEC has yet to finalize their regulations for registration and regulation of security-based swaps dealers, trade reporting, mandatory central clearing of standardized security-based swaps, and trade execution requirements. This incomplete and disjointed regulatory structure has resulted in discrepancies between the SEC and the CFTC's interpretations of Title VII, making it difficult for market participants to comply with these inconsistent regulations. One of the proposals before us today would require that the CFTC and SEC harmonize their over-the-counter swaps rules to provide necessary clarity to the market. It is encouraging to hear SEC Chairman Clayton say that the SEC and the CFTC are already moving in this direction. In a recent speech, he said, quote, "We are seeking to harmonize our ultimate securities-based swapped rules with the CFTC where appropriate to increase effectiveness as well as reduce complexity and costs. This requires deliberate and constructive engagement with our CFTC brethren, which I am pleased to report is well underway," close quote. The other proposals before us today fix many of the market irregularities that exist in today's derivatives markets. I would like to thank my friend and chairman of our Financial Institutions Subcommittee, Representative Lukemeyer, for introducing a bill that would require the appropriate federal banking agencies to recognize initial margin in the firm's leverage ratio calculation. The other proposals include drafts to help provide relief for derivatives end users, clarify the relief from mandatory clearing availability to centralized treasury units of non-financial affiliates, and accept swap transactions between affiliated entities from the swaps rules, clarify the definition of financial entity, excluding hedging swaps from the swap dealer de minimis threshold, provide clarity regarding the de minimis exception, annual thresholds for swap dealers and security-based swap dealers, clarify the definition of financial end user as it applies to parent and holding companies, and exclude non-U.S. regulated funds from the definition of, quote, United States person. As we address these current legislative proposals, it is important to note that derivatives are a vital part of the healthy functioning of our global economy. Companies of all sizes in Michigan and across the United States use derivatives to better manage the risks that they face every day. Derivatives help to ensure that prices are stable and that customers are not subject to immense market fluctuations. We must work to ensure that the derivatives market is appropriately regulated and is working efficiently to benefit Main Street investors. And with that, I will yield to the gentlelady from New York for her 5 minutes for an opening statement.
I thank the chairman for holding this important hearing and welcome all of our guests today, particularly my former colleague and friend, Kent Benson. Always a pleasure to see you. This hearing will examine 11 different derivatives bills. While I've never believed that Dodd-Frank was perfect, I think it's important to remember why Dodd-Frank created a regulatory regime for derivatives in the first place. Derivatives played a central role in the financial crisis. They turned losses on subprime mortgages in the U.S. into a global financial crisis, allowed financial institutions to take on excessive risks, and created dangerous connections between financial institutions that spread and amplified risk across the entire financial system. It was derivatives that brought down AIG, a 90-year-old company that was one of the largest financial institutions in the world. Taxpayers were forced to spend $180 billion to bail out and restructure AIG, which failed because of risky, unregulated gambling on credit default swaps. This is why Fed Chairman Ben Bernanke testified, and I quote, "Making derivatives safer is very important part of solving too big to fail and preventing another financial crisis." Dodd-Frank created a comprehensive regulatory regime for derivatives so that they would never bring down the financial system again. Under Title VII of Dodd-Frank, over-the-counter derivatives are now regulated by the CFTC and the SEC. Standardized derivatives have to go through central clearinghouses, trade on transparent exchanges, and be reported to regulators. Financial institutions have to hold appropriate capital against their derivatives and have to post collateral on their derivatives every single day. This has all contributed to a derivatives market that is vastly safer than it was before the crisis. But Congress did recognize that lots of companies use derivatives to hedge their day-to-day risks and not to take speculative bets. That's why Dodd-Frank specifically exempted these companies, which are known as end users of derivatives, from many of the new regulations in the bill. And when sufficient evidence was presented to this committee that end users were being inadvertently swept up in the regulatory regime intended for big banks and hedge funds, this committee acted on a bipartisan basis to tweak the law to protect end users. And that bill ultimately was signed into law, and I remember it well because it was attached to the Terrorism Risk Insurance Act, a bill that was very important for New York City, the area I represent. Congress also acted on a bipartisan basis to clarify when certain derivative trades between affiliates of the same company could be exempt from some of the Dodd-Frank rules. And Congress made these changes because we wanted to ensure that derivatives remained available for the end user companies that rely on derivatives to hedge their day-to-day risks. But these were technical fixes that were identified immediately after Dodd-Frank passed and were intended to help legitimate commercial end users. So any additional changes to Dodd-Frank's derivatives rules needs to satisfy, in my opinion, a high burden of proof for me to support rolling back rules on the derivatives market just because they are inconvenient for some institutions. There needs to be a real concrete problem that is both significant and unintended in order for me to support further changes to Dodd-Frank's derivatives rules. I look forward to hearing and learning today from the testimony of the board here today and from my colleagues. I yield my remaining time to my esteemed colleague from the great state of California, Mr. Chairman.
Thank you. Dodd-Frank was written in this room. It did not come down to us from Mount Sinai. I'm open to changes. And at the same time, we need a secure financial system. As the chairman points out, the purpose of derivatives is to allow an investor or other end user to shift risk. Most of the time we shift risk, we call that an insurance contract. We need to make sure that whenever derivatives are issued, wherever someone is assuming risk, that they can handle that risk and that there is no possibility of a bailout, yes, or even worse yet, a telephone call from Wall Street saying we'd better bail out the issuer of that derivative or the entire economy goes down. AIG was in the insurance business, and all of their subsidiaries seem to have weathered the crisis except for the only one that was not regulated as an insurance company. That entity assumed risk, didn't have adequate reserves, and I yield back.
Gentlelady's time has expired, and at this point, the chair now recognizes the gentleman from Illinois, Mr. Hulkran, Vice Chairman of the Subcommittee.
Thanks, Chairman Huizinga. Thanks for holding this important hearing. It's not often that we get the opportunity for an in-depth discussion of derivatives issues, despite our committee maintaining some jurisdiction over derivatives. It's important for us to identify opportunities to provide relief from Dodd-Frank and Basel regulatory framework if it means lowering costs for companies simply interested in managing their market risks. As a former member of the House Agriculture Committee under Chairman Lucas, we used to have more regular opportunity to deal with these issues, but I do know how important it is for companies in my district, and especially in Chicago, to be able to effectively manage their market risk. We shouldn't have regulatory impediments that discourage legitimate hedging strategies. We want our markets to function in a way that allow for opportunities to lower overall costs. I'm very encouraged by a number of the legislative proposals under consideration today. I'm a co-sponsor of Chairman Luchtmeyer's bill calling for a narrow but practical change in the supplementary leverage ratio. I've also received positive feedback from my constituents on a number of draft bills under consideration, such as relief from the credit valuation adjustment, amending the definition of financial entity, and relief from mandatory clearing for centralized Treasury units that I hope to learn more about today. Thanks, Chairman, and I yield back.
Chairman yields back. I would like to address also the participation in the subcommittee hearing today, and without objection, any member from the Financial Services Committee is permitted to participate in today's subcommittee hearing. Mr. Lukemeyer and Lucas are members of the Financial Services Committee, and we appreciate their interest in this important topic. Today, we welcome the testimony of Kenneth Benson, Jr., President and CEO of the Securities Industry and Financial Markets Association, also known as SIFMA, Thomas Dees, who is Chairman of the National Association of Corporate Treasurers on behalf of the Coalition for Derivatives End Users, Mr. Andy Green, Managing Director of Economic Policy for the Center for American Progress, and Scott O'Malia, Chief Executive Officer, International Swaps and Derivatives Association, ISDA, and we appreciate your time and attention to this. Each of you will be recognized for 5 minutes to give an oral presentation of your testimony, and without objection, each of your written testimonies will be made part of the permanent record as well. So with that, Mr. Benson, you are recognized for 5 minutes.
Thank you, Chairman Huizinga and Ranking Member Maloney, members of the committee. I appreciate the opportunity to testify on Title VII of Dodd-Frank. As was pointed out, Title VII created a new regulatory regime for derivatives or swaps. SIFMA believes the key pillars of this regime, transparency requirements, central clearing, and capital and margin requirements, are beneficial to the market and should remain in place. But we're concerned that some of the regulations go beyond what is necessary to achieve Title VII's core objectives and may even conflict with other regulations. It is important for policymakers to evaluate these issues, including Congress. I'd like to offer SIFMA's view on 4 pieces of legislation being considered by the committee. First, inter-affiliate transactions centralize risk management between affiliated counterparties within a firm as they serve their clients. Inter-affiliate transactions don't raise systemic risk concerns because they don't create new exposure outside the corporate group or increase interconnectedness between third parties. We're concerned that U.S. banking regulators have incorrectly and uniquely imposed initial margin requirements on such transactions, whereas the CFTC and other jurisdictions have not. Some SIFMA members report that they're locking up more margin for risk-reducing inter-affiliate transactions than they're collecting from third parties. These requirements discourage prudent risk management strategies and make it more challenging to provide hedging solutions for end-user customers. This also locks up capital that firms could allocate to invest in the broader economy. We believe that a logical solution would be to exempt inter-affiliate swaps from initial margin, mandatory clearing, and mandatory trading requirements, so long as they're part of a centralized risk management program and remain subject to variation margin and trade reporting requirements. SIFMA accordingly supports legislative measures to fix the treatment of inter-affiliate swaps. We believe that any such measure should apply consistently across all U.S. regulators. Second, Title VII's distinction between swaps and security-based swaps did not accurately reflect market practice, and the jurisdictional split between the CFTC and the SEC has posed challenges. Despite efforts by the agencies to coordinate and harmonize, there are important differences remain. Some areas where more work is needed include reducing conflicts with other legal regimes. For example, the SEC has adopted certification and legal opinion requirements relating to the SEC's access to a non-U.S. dealer's books and records, which create conflicts with foreign laws that the CFTC has sought to avoid. Second, following consistent international standards for margin and reporting requirements, which helps promote a level playing field and efficient coordination among regulators. And third, recognizing instances where satisfying another regulator's requirements would achieve a comparable outcome while avoiding overlapping regulations. The SEC and CFTC should look for more opportunities to leverage each other's rules for dual registrants. We support recent efforts to consider additional harmonization, such as indicated in recent speeches by Chairman Clayton and Giancarlo, and look forward to contributing to this dialogue. We also encourage coordination between market regulators and banking regulators, especially on capital and margin. Third, completely risk-insensitive leverage capital measures, such as the supplemental leverage ratio, are becoming binding capital restraints for many banking organizations. As a result, the amount of required capital is increasingly unrelated to the level of risk taken. This could lead to insufficient or excess capital levels depending on the prevailing economic conditions. One particular problematic area is the SLR's treatment of centrally cleared derivatives. When a firm clears derivatives for a client, the firm guarantees the client's obligations to the clearinghouse, collects initial margin from the client to secure these obligations, and segregates that margin. Although this initial margin largely offsets exposure to the client and the clearing firm cannot use the margin to fund its business. The SLR does not recognize an offset for the initial margin. Because the SLR requires clearing firms to hold capital against client exposures far in excess of the risk, it discourages client clearing. This incentive runs counter to Dodd-Frank's mandate to promote clearing. SIFMA supports H.R. 4659 as it would deduct client-provided initial margin on cleared derivatives from the leveraged exposure for the clearing firm and requires amendments to the capital rules to reflect this change. This is one of several changes policymakers should consider with respect to the SLR. Lastly, Title VII exempts a person from being deemed a swap dealer if the person engages in only a de minimis quantity of swaps connected to its dealing activity. When the CFTC and the SEC initially adopted rules implementing these provisions, they did not have data sufficiently inform the process. They therefore set their de minimis thresholds conservatively with automatic reductions over a period of time absent of rulemaking. We have concerns that decreasing the de minimis threshold would reduce the number of market participants willing to deal in swaps with commercial end users. Such an outcome would reduce liquidity and concentrate swaps with larger institutions. We believe that the changes to the de minimis threshold must be supported by robust data, and we support the CFTC's recent order providing for additional time to make informed decisions on this issue. Thank you for the opportunity to present our views, and I look forward to your questions.
You can tell Mr. Benson's an expert witness. He is turning back time, and the chairman can't even jam it all in the time allotted, so way to go. With that, Mr. Dees, you are recognized for 5 minutes.
Good afternoon, Chairman Huizenga, Ranking Member Maloney, and members of the subcommittee. I'm Tom Dees, Chairman of the National Association of Corporate Treasurers, which is a member of the Coalition for Derivative End Users. Our coalition represents hundreds of end-user companies across the country that employ derivatives to manage day-to-day business risks. I'd like to thank you all for doing so much to protect Main Street companies from undue burdens of financial regulations. We support the transparency that the Dodd-Frank Act attempts to achieve in the derivatives market. We also believe it's sound policy and consistent with the law to exempt end users from provisions intended to reduce the inherent riskiness of swap dealers' activities, but which can increase end users' cost and make our risk management activities prohibitively expensive. As you consider potential changes to Dodd-Frank and its implementing regulations, I want to assure you that end users comprising less than 10% of the derivatives market are offsetting business risks, not creating new financial ones. We support legislative changes to address first Bill number 2 on the agenda related to capital charges. A bipartisan consensus has clarified that commercial end users are exempted from having to post cash to margin their derivatives positions. However, U.S. prudential banking regulators are requiring swap counterparties they regulate to hold extra capital against an equivalent against end users on margin trades. This effectively negates the exemption with an equivalent economic cost that end users must bear. This credit valuation adjustment not only adds costs that can make hedging business risk too expensive, but places American companies at a competitive disadvantage compared to their European and other foreign rivals, whose regulators have exempted their end users from this burden in recognition that their derivatives are reducing overall economic risk. Next, bill number 3 on the agenda, the financial entity definition. The coalition believes that end users employing derivatives to reduce their business risk should not be unduly burdened with regulations intended for those running open books of positions such as swap dealers. The unifying characteristic for the end user exemption should be the exact matching of a derivative with an underlying business exposure, not whether the end user is engaged in certain activities which might be considered financial in nature. Take a real estate company which owns and manages factory buildings and supporting infrastructure and leases them to manufacturers. If this company is organized as a real estate fund, it's characterized as financial. And under the current rules, it cannot hedge its business exposures in the derivatives market without being subject to the full range of regulations applied to financial counterparties. We support proposals that would follow European, Canadian, and other foreign regulators that have set thresholds for financial activity below which companies would be treated as commercial end users. Now, finally, relating to bills 4 and 5, on the agenda on inter-affiliate exemption and centralized treasury units, end-user treasurers have long widely used the accepted risk reduction techniques of netting exposures within our corporate groups so we can reduce derivatives outstanding with banks. We use centralized treasury units as the hub for netting out opposite-way inter-affiliate derivative transactions to achieve this reduction in outstanding hedges. These CTUs allow us to centralize control and compliance supervision across often far-flung corporate groups. However, the commercial end-user exemption needs legislative clarification to ensure it applies to CTUs and the inter-affiliate derivatives centralized through them, so they are not subject to mandatory clearing and the requirement to post margin for these internal notional derivative positions. In conclusion, end users employ the OTC derivatives market for the efficient transmittal of risk from where they incur it to where they can match and offset it with a swap dealer. Undue regulatory costs along the way, including those placed on our financial intermediaries, are ultimately borne by the end user. In our world of finite limits and financial constraints, these unintended economic burdens on end users represent a direct dollar-for-dollar subtraction from funds that we would otherwise use to expand our plants, to build inventory, to support higher sales, to conduct research and development, and ultimately to sustain and we hope grow jobs. I noted in my written testimony specifics of these concerns along with suggested remedies and will do my best to answer questions you may have. Thank you again for your attention to end-user companies.
Thank you for your testimony. With that, Mr. Green, you are recognized for 5 minutes.
Thank you, Chairman Huizenga and Ranking Member Maloney, for the opportunity to testify on this important topic. The derivatives market is a vital avenue for financial and non-financial companies to prudently hedge the risks they face. Today's roughly $550 trillion swaps market may not directly impact the day-to-day lives of the average American, but a severe disruption in the market can have knock-on effects impacting the real economy and them. The unregulated swaps market was at the heart of the 07-08 financial crisis, which cost 8.7 million Americans their jobs, 10 million families their homes, and helped eliminate 49% of the average middle-class family's wealth compared to 2001 levels. Thanks in part to the unregulated swaps market, financial distress in one company quickly reverberated throughout the financial system. AIG is the only most commonly discussed example, but every other major Wall Street dealer bank faced major threats from margin calls and the risk of knock-on losses arising from swaps. Nor was the 08 financial crisis the first time swaps markets created major challenges. Long-term capital management, Enron, Amaranth, Grips and Greeting Cards, Procter & Gamble, Orange County, all got themselves in trouble in one way or another from the OTC swaps market, negatively impacting investors, market participants, financial stability, and taxpayers. In the wake of the devastation wrought by the financial crisis, Title VII of Dodd-Frank sought to bring stability, transparency and competition to the swaps market. Nearly 8 years since Dodd-Frank was signed into law, with the exception of the SEC, the swaps regime is operational and working, and it's benefiting the real economy. In just one study, the Bank of England found that in the U.S., total execution costs for end users are reduced by about $7 to $13 million a day for self-mandated swaps. With reform showing positive results and the large investment in operations and compliance systems already made by firms, any legislative proposal should have to overcome a heavy burden in favor of maintaining what is working. Financial regulatory changes also need to be considered as a whole. For example, FSOC's designation process, which helps reduce the risks that non-bank financial firms create knock-on effects across markets. The Office of Financial Research monitors and investigates the risks across the financial system. And other regulatory protections, such as bank capital, liquidity, and the Volcker Rule, which properly distribute risk and focus firms' activities on the real economy, appear under threat. To the extent that these tools are dialed back, it places even more strain on any weaknesses that may emerge in the derivatives markets. Unfortunately, the bills presented today all appear to press in the wrong direction. A persistent theme in them is to extend the scope of commercial end-user treatment to entities and activities that are financial in nature. This violates the basic bargain that strong regulatory protections cover the market, which is dominated by financial firms, and that special treatment can be accorded the relatively small number of commercial entities. To draw an analogy to public health, a small number of people can avoid being immunized and still remain protected by the broader use of a vaccine. But if that group becomes too large, everyone is put at risk, especially those people who actually cannot be immunized. To the extent that any of the bills today embody specific concerns by market participants, far more needs to be done to study specifically identified challenges. To facilitate accurate analysis and broad-based consensus on these questions, far more market and institutional data, including at the subsidiary level, must be made available to and usable by the public. Lastly, policymakers should avoid falling victim to the argument that reducing regulation will enhance competition and benefit end users or the real economy. Financial markets have a tendency towards rent-seeking behavior, which comes at the expense of the real economy. Regulatory standards are required to ensure transparency and competition, which benefit those that utilize these markets. Small and medium-sized enterprises, family farmers, manufacturers, energy and commodity companies are far better served by a simple, robustly regulated market where prices are transparent and competition is meaningful. I've addressed the specific proposals today in my written comments, and in the interest of time, we'll stop here. I look forward to taking your questions. Thank you.
Thank you. And with that, Mr. O'Malley, you are recognized for 5 minutes.
Chairman Huizenga, Ranking Member Maloney, and members of the committee, on behalf of the International Swaps and Derivatives Association and its 900-member firms, I'd like to thank the committee for holding this timely hearing to discuss potential adjustments to the regulatory regime of the derivatives market. I'm pleased to offer my written testimony where I have addressed in great detail my observations regarding the progress that has been made to implement Dodd-Frank, the important initiatives taken by ISDA and its membership to develop mutualized solutions to optimize implementation of the rules, and then more specific recommendations on the legislation before this subcommittee. The implementation of Dodd-Frank and the related margin and capital rules have made the financial market more transparent, more resilient, and have reduced systemic risk. Over the past 7 years, ISDA and our members have made significant progress in implementing the regulatory agenda. Today, trade data on derivatives is now required to be reported to SDRs and fully accessible to regulators. Nearly 88% of interest rate derivatives and 80% of CDS index notional traded in 2017 is centrally cleared. More than half of all interest rate derivatives in the U.S. were traded on an electronic platform in 2017. Globally significant banks have added $1.77 trillion in Tier 1 capital to their balance sheet since 2009, and further increases are contemplated. Nearly $1 trillion of collateral has been posted by counterparties with the 20 largest market participants to back the risk of the non-cleared swaps, and we're only halfway through that process. It's important to stress that we are in no way advocating for a rollback of this progress. However, with any regulatory reform this size and this scope, we are bound to find areas where anticipated outcomes and the actual results don't align, creating redundancies, higher costs, or areas for improvement. Now, we believe that these improvements can be made to the current regulatory regime by focusing on 3 broad areas. First, harmonizing regulatory requirements. Second, reducing operational complexity and cost. And third, providing regulatory relief to market participants, small market participants, and end users. Let me begin by discussing the need for greater regulatory alignment. As we all know, both the CFTC and the SEC have oversight over parts of the swap market. Ideally, we would have an effective, identical requirement for the market segments the two agencies oversee. However, such an outcome has proven to be difficult to achieve in practice. As a result, ISDA recommends that the CFTC and the SEC develop a more holistic solution, a safe harbor approach, to address these issues. Under such an approach, market participants in compliance with the CFTC rule sets for swaps, including business conduct, capital, and margin, would be granted a safe harbor from the same rule sets issued by the SEC and vice versa. To be clear, in either case, the derivative activity would be thoroughly regulated. Most importantly, the safe harbor approach does not contemplate the relinquishment of the agency's respective authorities or jurisdiction. Both commissions would retain anti-fraud and anti-manipulation enforcement authority, and the respective congressional committees would retain their legislative and regulatory oversight. One final word on this matter. While it has taken significant work between the U.S. and Europe to find a solution to recognize one another's clearing and trading rules, it would be quite remarkable if we were able to achieve a determination with a foreign government, but not within our own. Turning now to a second area where greater global regulatory harmonization is needed, and that's the treatment of inter-affiliate transactions under the margin rule. My former colleague, Chairman Gary Gensler, explicitly recognized the benefits of such transactions when providing an exemption from the clearing requirements. This position enjoyed bipartisan support on the Commission. His successor, Tim Massad, further memorialized the CFTC position by providing an exemption from the initial margin requirements, which are consistent with policies in the EU and Japan. Now, the rules promulgated by the U.S. prudential regulators, however, do not provide such an exemption and disadvantage certain firms doing business in the U.S. and abroad. The legislation being discussed today would remedy this disparity. Moving on to my second theme is reducing operational complexity and cost. I can think of no better example than the treatment of margin under the supplemental leverage ratio requirements. In its current form, the leverage ratio acts to disincentivize central clearing, adding to costs of banks to provide this service. This perverse impact has been highlighted by numerous policymakers over the past several years. This is not a partisan issue. CFTC chairmen under two separate administrations have raised these concerns. It runs counter to the objectives of the G20 as implemented by Congress in Dodd-Frank and to encourage centralized clearing. Now, the final broad area which I will discuss is providing relief to small market participants and end users. ISDA believes that Congress can have an immediate impact on this. We applaud the committee's focus to address the unlevel playing field created by the credit valuation adjustment, providing a technical fix to the exemption of centralized treasury units, and ending the uncertainty over the CFTC's swap dealer de minimis threshold. As noted earlier, ISDA and its members support a safe and efficient market, and we have worked hard to implement the regulatory reforms to increase transparency and mitigate systemic risk. ISDA looks forward to working with Congress, the U.S., and international regulators to develop solutions to further strengthen, simplify, and harmonize the regulatory framework. Thank you very much.
Thank you. And at this time, I'd like to recognize myself for 5 minutes. Real quickly, and this wasn't in the oral testimony, but in written testimony, we saw Mr. Green compare the different rules from different agencies as different types of transportation modes having different types of safety rules. It seems to me that it might be the same highway, but we now have the state police setting truck speeds and safety rules, and while the county sheriff is setting vehicle speeds, private vehicle speeds on those same highways and roadways. Mr. Benson and Mr. Dees, maybe Mr. Dees first, how are these end users generally different from other participants in the OTC derivatives markets, and did the derivatives activity by end users contribute to this financial crisis that we had seen previously?
Thank you, Mr. Chairman. The fundamental difference between end users and the other participants in the market is that to qualify as an end user, you must be matching a derivative exactly as to timing, amount, currency, whatever the characteristics may be, with an underlying business exposure. So the exposure of the day-to-day business risk and the derivative are matched and they offset each other exactly. Whereas swap dealers are maintaining an open book. At times, that book doesn't balance, and positions going one way may exceed those going another way. And so they incur through that imbalance a risk, and it's proper, we think, that there be appropriate capital and other charges related to those risks. End users comprise less than 10% of the derivatives market and did not contribute to systemic risk.
I guess I would just add, this is a little bit of a dilemma inherent in the U.S. Regulatory framework that this committee and its predecessor committees have dealt with over the years, in terms of where you have products that are providing the same function but are differentiated by legal definition, and really you run into a situation of functional regulation, which is sort of the U.S. framework that we have in place. And in our mind, it doesn't make a lot of sense for regulators to have differing regulation for the same product just because of the legal definition. And it actually seems, in our mind, to run counter to what has been at the top of the House at the U.S. in multiple administrations, in the agreements that are worked out amongst the G20 and the Pittsburgh principles of having harmonization across jurisdictions, particularly in what is a global marketplace. So I think having different enforcement schemes is not necessarily the best approach.
So ultimately, you believe the inconsistencies have affected compliance and
it creates fragmentation.
Fragmentation.
And it creates fragmentation in what is a global market, and affects everything from execution, price, and availability.
And not in a beneficial way, I think, has been.
No, I mean
asserted.
we've seen in some of our buy side members have done surveys where they've seen cost of execution go up, number of entities who are willing to provide clearing services go down. So and then even in the cross-border regime realm, where we've seen fragmentation in markets, which reduces liquidity, which we don't think is a good thing.
So ultimately, do you believe the CFTC should be granted the authority to issue the fees on derivatives? I mean, that is something that has been proposed in the budget by the White House, and I'm curious how it would affect market participants and liquidity in the marketplace. Maybe have you address that, Mr. Amalia. Mr. Amalia, if you want to go first.
Thank you. This proposal has come up time and time again in different forms and in different administrations, and each time has been rejected because it adds to the cost of risk management. We don't support the fees proposed in the budget.
Neither does Mr. Giancarlo, but I don't know if Mr. Benson or
I think Scott makes a fair point. And I think what's and Chairman Giancarlo did come out against this the other day, and there's a question of how you let in some cases you could have a fee that exceeds the spread on the product, and so you have to take that into consideration as well.
Okay. With that, I will yield back my time and recognize the gentlelady who is freshly returned from the floor as we're debating some financial services bills down there. The gentlelady from New York is recognized for 5 minutes.
Thank you. I thank the gentleman for recognizing me. I'd first of all like to ask Mr. Green, as I mentioned in my opening statement, I think that there should be a very high burden of proof for any bill that makes additional changes to Dodd-Frank's derivatives rules. There needs to be a real, concrete problem that is both significant and unintended before I'm willing to support legislative change for derivatives rules. In your view, Mr. Green, do any of these bills meet this high standard of proof? Are any of the problems that the bills are addressing significant enough to warrant legislative action?
Thank you. No, they do not on both questions. I do not believe that they are no to both questions.
Well, Mr. Green, as you know, Dodd-Frank excluded legitimate commercial end users from many of the derivatives rules that were only intended for banks and hedge funds. One of these bills would extend the end user exemption to commodity pools and even to private funds. Are these legitimate commercial end users, or are they more like financial institutions? And do you think it's appropriate to treat these entities like end users?
Thank you. Absolutely not. Despite the name commodity pool, this is not someplace that drained the water in their backyard pool and has filled it now with corn and wheat. These are basically mutual funds or private funds that are offered to investors or other market participants for the purpose of investing. And I use that term with a little bit of quotes because the commodities markets and the commodities derivative markets are different from normal SEC investment markets. But they are not, they are for the purpose of investment, they are financial activities. They are not owning commodities or engaged in those types of activities. And so it is really quite inappropriate to extend end user treatment to them. And I would even argue that the real estate funds, we've seen from the financial crisis and in other cases that real estate can be a major source of speculative bubbles, and that prudent risk management of a financial nature is essential when you're engaged in these types of financial activities.
Well, Mr. Green, one of these bills would reduce the capital requirement for banks that are trading derivatives with end users. How would giving relief to banks on their derivatives trade help end users?
I don't believe that it would, and I believe the evidence, what we've seen with respect to capital and the approaches to capital overall suggests that it does not historically. Capital, it's important to remember that it's frequently understood that capital is something people talk about it being held by a company. It is not. It is a form of funding. It is there so that firms can withstand losses and be flexible with response to changing market conditions. And in this particular bill you're referencing, it's very essential that fair value risks of credit as they change are appropriately included within capital. And we are already, with looking at banks overall, very, very much at the bare minimum in terms of a socially responsible level of an equity capital buffer. Any steps taken to reduce that would be very unwise.
Okay, do you think banks would pass on this relief to end users in the form of lower trading costs?
No, I don't believe the evidence is that that would be the case. I believe that trading costs are lowered when you have competition and real transparency in the market, and that's why those types of parts of the reforms are essential and need to be advanced further.
Or would this simply make trading derivatives more profitable for banks?
It would certainly make it more profitable, but it would certainly make it more profitable. But really what it does is it creates more of a risk that is being borne by the taxpayer and the resolution regime that would have to step in if the equity was not there to absorb the risks of losses. It's important to remember that capital and even margin only cover a small portion of the estimated risks that are created by these exposures. When models fail and other problems emerge, we need a sufficient buffer to be able to withstand what happens in the markets. And those benefits would not go on to the end users.
Well, thank you very much. My time has expired. Thank you.
Gentlelady yields back. With that, the chair recognizes the Vice Chairman, Mr. Hultgren, for 5 minutes.
Thanks, Chairman. Thank you all so much for being here. I'm going to address my first question to Mr. O'Malley, if that's all right. It's a multi-part question. Is it practical for the credit valuation adjustment to apply to derivatives transactions with end users that are designed for hedging purposes? And do you believe U.S. bank regulators were attempting to address an issue, or was this simply an oversight? And why would the EU's implementation of the Basel framework exclude hedging transactions with end users from the CVA calculation?
Thank you very much. The capital rules are really developed as global rules, and through the Basel Committee, they're trying to establish a consistent regulatory framework. That is very important because, as was noted earlier, these are global markets, and so you're dealing with global banks with end users that can trade in different areas and access liquidity, and it's very important that we align those rules in a very comprehensive and consistent fashion. As you quite rightly pointed out, the European Commission did not impose a CVA charge, chose not to do that, and so right now we're trying to assess what the new Basel requirements would do to impact U.S. traders. And it's very important we do the economic analysis. I don't think the data will hide the fact that this is more expensive for end users if you have these in place. And then you have to reconcile the international standards and balance and what that does for U.S. competitiveness.
I wonder if you could maybe detail even a little bit more some of the unintended consequences of the current CVA treatment. For example, does the current CVA treatment disincentivize hedging by instituting a punitive capital framework on banks for engaging in hedging transactions with end users? And are U.S. banks and end users at a disadvantage to their European competitors?
Yeah, I believe they are, and there's several of these capital rules, whether it's the leverage ratio that adds costs while you're including IM into for cleared risk, that doesn't take that into consideration. There's a number of different capital rules that are just going to increase the cost to end users in these positions, making it more expensive to either access capital and or access clearing, which is clearly a mandate and a goal of Dodd-Frank.
Yeah. Thanks, Mr. Malia. Mr. Diaz, if I could address to you, your testimony underscores what I think is widely recognized concern. When a company falls under Dodd-Frank's definition of financial entity, it's automatically precluded from qualifying for or otherwise electing any of the exceptions or exemptions for uncleared derivatives. Do you know the justification for why the law was written this way, if any?
Congressman, no, we feel that the relevant distinction should be an end user should be using derivatives to hedge underlying business risks rather than maintaining an open book as a swap dealer would do. So if that entity is, in my example, a real estate fund that owns factories and leases those to manufacturing companies, we would think that that should be exempt from these extra requirements, and failure to exempt such entities would ultimately result in costs being passed on to manufacturers.
Yeah. Do you believe the draft bill under consideration today, named Deriv 03, would address this issue and bring parity for these companies deemed as financial entities that use derivatives for hedging?
Our coalition does support the bill scheduled as Agenda Item 3, and that it would not only do that, but it would bring the U.S. in line with Europe, Canada, Singapore, Australia, and other of our foreign competitors.
Thanks. Mr. Benson, my last minute here. CFTC Commissioner Quintenas recently spoke at the conference in D.C. hosted by the Mercatus Center and the Institute for Financial Markets, where he focused on the need for updating the de minimis exemption for swap dealers and security-based swap dealers, noting, and I quote, "The threshold's reduction to $3 billion would create a black hole, sucking in community banks and end users who pose zero systemic risk. At the center of that black hole lies an enormous set of costs," end quote. Do you believe that legislation proposing to exclude all hedging from the swap dealer de minimis threshold would provide relief to those dealers concerned with exceeding the threshold?
So it's a good question. First of all, to your first point, and what the Commissioner was talking about, is a concern that if you, and as I said in my testimony, we really need more data to see, who is subject to the de minimis threshold. All the larger banks are obviously, well beyond the threshold in whatever level you're going to set at. But there are a lot of smaller dealers who are not subject to it, and our concern is that many of those smaller dealers might not be willing, while they pose no systemic risk, might not be willing to stay in the business if they're going to be subject to that compliance to serve their clients. They'll just trade it away to others. So you'll create more concentration in the market, and you'll take more players out of the market. So we think that the Commission needs to be very cautious in their approach here. They now are getting more data since these rules have come into place. Let's look at the data and see what it says.
Thanks. My time's expired. I yield back. Thanks, Chairman.
Gentleman's time has expired. The gentleman from California is recognized for 5 minutes.
Mr. Benson, welcome back. As market participants work to comply with U.S. derivative rules, do you have any suggestions for how U.S. regulators like the SEC, the CFTC, can achieve their regulatory objectives in situations where there are conflicts with international data privacy, blocking, secrecy laws in other jurisdictions?
Yeah, it's a very good question. It's something that, obviously national regulators have not only their legal mandate that the Congress or whatever body provides, puts forth for them, but when you're dealing with global markets, they're having to deal with other national laws and cross-border. In the case of the data reporting, the ability to look at books and records is a problem that both the SEC and CFTC are confronting The CFTC, I think, has tried to be more accommodative where they conflict with the national law, privacy laws that are in place. The SEC, I think, is still struggling with that, and we think that they need to do more work in that area. And it's something that I think I think the U.S. needs to be very cognizant of, because this can cut both ways. We've been through this process of trying to get equivalency regimes put in place for trading and clearing, where we've had foreign regulators who want to have access to books and records and the like in the U.S., and we've had to work through that process. So I think anytime we're negotiating with the foreign and trying to accomplish our goals and negotiating with a foreign entity, we need to consider the two-way street approach. And I think this is only going to get more complicated as we go through the Brexit regime.
One reference from outside this room is the exchange of information provisions that we have in our tax treaties, where we also have regulators, or in this case tax authorities, looking at the same regulation. Mr. Dees, you're here for the end users. A certain amount of capital is posted at various times with the exchanges. The question is whether this is adequate enough for you to assure me that that none of these end users that you represent is ever going to come to Congress and say, they didn't post enough capital, so they're now liable to us. We sued them, they're bankrupt, you've got to bail us out. Is there enough capital being posted so that none of your members will ever say, such and such a derivative issuer went under, and Uncle Sam's got to write a check?
Well, Congressman, thank you for that question. Just to address an answer Mr. Green just gave, I can't tell you that the vaccination regime we have guarantees that nobody will get sick. What I can tell you is that end users comprise less than 10% of the derivatives market by notional amount outstanding, and during the financial crisis represented a far lower percentage than that of defaulting parties.
Well, we may be in a circumstance where we need, if we had just required higher capital, we might be okay, but because we didn't, Uncle Sam has to write a check.
Well, sir,
or the entire economy falls apart.
End users seek to do their derivative transactions in the majority with Fed member banks or other regulated financial institutions of that type. And in our case, the Federal Reserve does stress tests and conducts other examinations.
And so
of
the
these
higher
banks.
standards that there are imposed on those you're buying derivatives from, the less likely it is that they will default, the less likely that either you or I will be holding the bag.
Well, we believe that there's an adequate capital cushion
Okay.
to guard against these kind of outlier events.
Okay. Let me just ask Mr. Green, this is insurance. I've got a comprehensive policy, auto insurance. If my car is stolen, I give the pink slip, which is what we call the title, to the insurance company. They write me a check for 20 grand. If instead we structured that as a credit to car swap, and we would say under certain circumstances, I give them the pink slip and they give me $20,000 worth of U.S. Treasuries, well, that would just be the trade of one piece of paper for another piece of paper. I guess it wouldn't be regulated as insurance. Why, and I realize this is national or international, so you might need a national regulator, but why don't we regulate this like insurance?
Quickly answer.
Very quick answer.
You make some very important conceptual points. We have not historically done that, but there are some very strong arguments why particularly certain parts of the market ought to be treated like that, particularly credit markets. And certain parts of Dodd-Frank do start to push in that direction, such as prohibiting a firm from betting against a securitization product that they issue. So I think there's a lot of conceptual backing to the argument you're making and ought to be explored further.
Gentleman's time has expired. With that, the gentlelady from Missouri is recognized for 5 minutes.
Thank you, Chairman Huizenga, and thanks to all of our witnesses for being here today. Many of you are repeat customers. The 2017 Treasury Report on Capital Markets contains recommendations for the CFTC and the SEC to undertake a joint effort to review their respective rulemakings in order to eliminate redundancies. Mr. Benson, in your testimony, you also note, and I quote, "The regulatory distinctions between swaps and security-based swaps, as defined under Title VII, did not accurately reflect market practice, and the resulting jurisdictional split between the CFTC and SEC has posed challenges for market participation." Mr. Benson, can you please briefly explain how the different regulatory timelines and approaches under both the SEC and CFTC have created these inconsistencies and redundancies?
I think what we're finding is again, in some of a lot of it's in my testimony, but treatment of rules in terms of how you define U.S. person, and again, so a lot of the rules the SEC has not finished yet, so they're still in the promulgation period, but have sort of moved have not clearly been moving in the same direction. We think where we are now is an opportunity with the Treasury recommendations, with the two new leaders of the two commissions, to try and create either harmonization or, as one of the other witnesses testified, safe harbor approach or substituted compliance approach between the two regimes.
Thank you. Mr. O'Malia, you also talked about duplicative requirements in your testimony and for a need to level that playing field. For some market participants who must adhere to both sets of rules, how do these different approaches for many of the similar activities and products create compliance concerns and additional costs?
Well, the operational challenges of implementing dual sets of regulation, and we have examples on a global level, in particular the data rules. Each jurisdiction requires a different data reporting regime. I think we have to look at this in a very practical approach, and then also look at it what results do you want to achieve. Now, the CFTC and the SEC have largely well-aligned swap dealer definitions and rules. They're being implemented on a different time frame. So the results you're going to get if you deal with a safe harbor approach, basically saying to the extent you've complied fully with the CFTC rules for swap dealer registration and meet all those, you're compliant with the SEC, or vice versa if you chose to start with the SEC. Now this would, the two agencies could work together to figure this thing out.
How about a holistic approach? What about that?
Well, we would like a safe harbor approach. You comply with one or the other, and there are examples of this that we achieved at the CFTC back in 2013 with FERC. We were not the FERC tariff rate setter, but yet we had jurisdiction over some of those commodity markets. We deferred to the FERC to make those decisions. These are workable solutions. We also work with other SROs to defer some of that regulatory oversight. So it's imminently possible and available to us. It is, letting the chairman sort this out, giving the strong direction from this committee and others to get those results. And then I think you'll have an operational solution.
I appreciate your elaborating, especially on the regulatory safe harbor testimony that you've given. Mr. Benson, since the U.S. and EU have been able to determine regulatory equivalence in terms of clearing and trade execution rules, does it make sense for the SEC and CFTC to do the same within the U.S. regulatory framework?
Yes, I think so. Yeah, absolutely. I mean, I think that, again, as I mentioned before, we have functional regulation in the U.S. that sometimes is defined by legal definition, but where we're talking about similar products. And so I think that we should certainly domestically try and have similar coordination that we're trying to do cross-border.
Many requirements in the Title VII of Dodd-Frank tasked the SEC and CFTC with virtually identical rulemakings. So one would think that requirements for swaps and security-based swaps would be very similar, if not identical. Has this been the case, Mr. Benson?
Again, I think as we've gone through the rulemaking process, we've seen that there have been differences in interpretation of Title VII between the two regulators. So I don't want to just say that it's necessarily one regulator versus another. I think in both cases, and to be fair, they've come at it from their legacy focus, right? So the CFTC was much a futures regulator, the SEC obviously a securities regulator. And so, but as we've had some experience now, 7, 8 years of experience. This is really something where we should be able to converge, or just, as Scott said, employ a safe harbor approach.
Appreciate that. My time's expired. I have some other questions, Mr. Chairman, that I'll submit for the record. I thank the witnesses, and I yield back.
Gentlelady's time has expired. Gentleman from Massachusetts, Mr. Lynch, is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to thank the witnesses for your help on this matter. First of all, this grouping of bills, the 11 bills that are presented, they're not actually bills, they don't have bill numbers, but I guess they could call them proposals, taken in the aggregate would wipe out much of the taxpayer protections that were put in place by Dodd-Frank after the crisis back in 2008. In particular, one of the bills before us today, H.R. blank number 6, I guess, at least that's in the memo, creates a large exemption for swaps between, quote, affiliated entities, close quote. They'd be exempt from CFTC and SEC regulations. We've addressed this before during Dodd-Frank and subsequent to that. We've previously considered this matter with input from both Treasury and the FDIC. And we've got some pertinent communications, specifically from Vice Chairman Tom Hennig of the FDIC. And I think it's instructive that he says, inter-affiliate margin ensures that there is sufficient capital and liquidity to the financial firm and the market should any unit of a consolidated bank company find itself in a position where it cannot serve end users, or where its failure becomes a threat to the broader economy and the taxpayer. Chairman Hennig then pointed out that affiliates are incentivized to transfer their risk through uncleared swaps to U.S. banks, who have valuable subsidies, including, importantly, the implicit presumption that they will be bailed out by the U.S. taxpayer. If the banks don't collect margin from their affiliates on these trades, the bank effectively takes on the affiliates' risks, which are subsidized, again, by the taxpayer. Mr. Hennig also wrote that requiring, as an example, he said, by requiring J.P. Morgan's affiliate operating in London to post margin to J.P. Morgan's U.S. bank, that would have helped keep the $2 billion London whale losses outside of the federally insured bank. I think it's a great example in what we're talking about here today. The bill would also eliminate the CFTC's initial margin requirement for swaps with foreign affiliates that are not subject to comparable regulatory regime, again, exposing us to considerable risk. Mr. Green, are we seeing here a case of a purported exception actually swallowing the rule? If an affiliate is described too broadly, couldn't companies simply funnel their derivative trades through a so-called affiliate to evade U.S. requirements?
Yes, I agree with that. I think this is an area that's extremely dangerous. It's extremely broad. Some estimates are at inter-affiliate swaps are up to half of the swaps that are out there. The large financial firms have thousands of affiliates. Now, the most important affiliates are a smaller number of that. But given the interactions between resolution and also cross-border, where a lot of the conversation about inconsistency in CFTC versus SEC regulation that was just noted a couple of minutes ago are actually about the extent to which, foreign affiliates are subject, that are foreign affiliates of U.S. firms, where the risk will come back to the U.S., are subject to the basic protections that we set in place for the U.S. taxpayer. If you start to undermine those, you have major challenges. Now, Chairman, as Commissioner O'Malley has noted, Chairman Gensler and others have noted there are distinct differences that require these swaps to be tailored slightly, and we can discuss and debate particularities, but the bill that's presented today is a broad-based exemption that's not acceptable.
Right. What does this bill do to the requirements for posting margin with foreign affiliates that are not subject to overseas regulatory regimes that are comparable to our own. You touched on that a little bit, but I'm just concerned that aren't we just creating a loophole to allow foreign funneled trades to have an advantage over U.S. banks that don't operate through a foreign affiliate?
Absolutely. This is, anytime you're getting into a description like you mentioned, I think that is a very real risk. This is the Export U.S. Financial Service Jobs Abroad Act. This is import foreign risk into the U.S. because the U.S. taxpayer, for a variety of reasons, has been the one that has had to step up and make sure that U.S. financial institutions are there when need be. A far more appropriate approach is to ensure a broad, consistent, using substituted compliance, comparability regime so that there's good regulatory approaches around the world, and where there are not, we need to make sure that the U.S. regulatory regime is the floor and that no one can evade it with a large exemption like the one that's being proposed in the bill today.
Thank you, Mr. Chairman. I yield back.
Gentleman's time has expired. Gentleman from Maine is recognized for
Thank you,
5
Mr. Chairman.
minutes.
Appreciate it very much. And thank you, gentlemen, for all being here today. One of the roles of government, as I see it, is to make sure that we create laws and rules are made such that our families are helped and such that they live better lives with more opportunity and more freedom. That's why I've been a very big proponent and continue to about reducing or eliminating the regulatory environment that's redundant and unnecessary and harmful. And second of all, well, I've been a big supporter of our tax reform package, which is being quite successful as far as stimulating economic growth and job creation here in this country, in my state of Maine. The state of Maine, gentlemen, has world-class fisheries and agriculture and also wood products. We have a tremendous resources, natural resources with our sustainable forests and what have you. I'm really concerned about some of the folks on the other side of the aisle today saying something to this, and I'll paraphrase, I hope I get it right, that they're concerned about any adjustments to Dodd-Frank when it comes to derivatives because they believe that doing so will represent or cause potentially systemic risk to our economy. Now, what would be helpful to me, Mr. Dias, if I'm pronouncing it correctly.
Dees, sir.
Dees, thank you, sir. Is could you use a specific example of an end user, say a potato farmer in Aroostook County, how such an end user might use such a derivative, such a financial instrument to help that farm conduct its business to lower its risk so it can grow, be more successful, and also offer more price stability to the consumer. And explain to us clearly, sir, how that does not represent a systemic risk to the U.S. economy.
Yes, sir. Well, I'm privileged to have served 18 years as in the Treasury and Corporate Finance function at Scott Paper Company, which, as you know,
When I was a kid growing up in central Maine, Scott Paper was a great employer right across the river in Winslow, Maine, and we appreciated those jobs. My best buddy across the street, his dad was a machinist at Scott Paper. Thank you for that job.
Thank you, sir, and it was my privilege to finance the construction of those operations. And I can tell you, for example, at the Winslow Mill, where there are energy, quite a bit of energy is consumed in the transformation of wood pulp into paper. Those energy exposures, to the extent they're variable, represent a risk to the business. And to the extent that at Scott Paper Company's treasury, we're able to hedge those energy purchases forward in the over-the-counter derivatives market, matching up exactly the exposure of when we're buying the energy and against the derivative. It helps stabilize the business, maintain level cost base, and ultimately support those jobs in Winslow.
And so that, in your opinion, sir, represented no potential systemic risk to the U.S. economy?
We think it's risk reducing, and the Europeans have taken the same view and exempted their end user companies from many of these regulations we're advocating be adopted in the U.S.
Mr. Benson, do you have a further experience that could shed light on this issue where the end user is representing no risks to the U.S. economy?
Well, I think Mr. Dees is laid it out well. The end user is effectively buying a product to mitigate their risk or to hedge their risk activity. And so they're really in a different function than in a financial risk.
Explain to us if a paper company like Scott might not have the ability to hedge its risk, how that might be more risky to the economy and to the families that depend on those jobs.
I mean, again, Mr. D is probably better to speak on this, but the fact you talk about having to mitigate your risks to fluctuations in the cost of fuel or feedstock for your plants, or fluctuations for a global company, fluctuation in currency prices.
How might there be some confusion, gentlemen, either one of you, between this issue that we're talking about and the use of derivatives in other parts of the economy that could have and did in some parts cause problems in 2008?
Yeah, I mean, I think first of all, we have to step back and look at where we are today compared to where we were in 2007, 2008. We have a very robust new architectural regime that's been put in place for the derivatives markets in the U.S. and across the globe. And much of what we're talking about today is how do we, in what is truly a global marketplace, how do we make sure that the plumbing is the same across the organization? We don't create fragmentation or diminish liquidity in different market sectors. So companies like Scott Paper or a global company can function globally as well. So here we're talking about, do we have the calibration right after 7 years of imposing a dramatic series of rules, many of which the industry supports? But the time is now to see what works, what doesn't work, and are we accomplishing the policy goals?
Thank you, gentlemen, very much. Appreciate your time. Thank you, Mr. Chairman.
Gentleman's time has expired. I'll point out that you had him at paper. So the chair at this time recognizes the gentleman from Georgia, Mr. Scott, for 5 minutes.
Thank you very much, Mr. Chairman. This is a very interesting and very important hearing dealing with a very important matter. But first, I want to thank Mr. Lukemeyer for again partnering with me on some common sense legislation. And I want to devote that to our legislation that Mr. Lukemeyer working with, H.R. 4659, of which I'm the Democratic lead on. It forces banking regulators to recognize the exposure-reducing nature of client margin for cleared derivatives. Now, first of all, I recognize the importance of client margins, and I believe that client margins should be excluded from what we refer to as supplemental leverage ratio calculations. But more importantly, if we were to include client margin in supplemental leverage ratio calculation, it would put our clearinghouses at a very distinct disadvantage. And a major thing we wanted to do in Dodd-Frank was bring transparency to this over-the-counter market that previously operated in the shadows, as you know, of our financial system. But we made a decision as a nation to expand the use of central clearing. And so that's why I struggle to understand why anyone could not be supportive of putting together regulations that incentivize more companies to clear derivatives. That's what our bill, Mr. Lukemeyer and our bill 4659 does. It makes clearing more attractive to our country's biggest institutions. So, Mr. Benson, you and Mr., I think, O'Malley, I'd like for you to comment and explain, am I going wrong? Am I right? Does not our bill help in this matter?
Mr. Scott, I think you're right on point. This is counterintuitive and goes against what really was official policy of trying to drive more product that could be driven to central clearing, and now you're being penalized for doing it. It's one of the problems in the construct of the SLR that we think needs to be approached. So we think you all are right on target.
Now, let me ask you this, and Mr. O'Malley, you can comment too, because it's good to get on the record questions. I try to be able to not just look down the road, but look down the road and around corners to see what might be coming. And I think as we get further in this bill, a question might be raised that what we're trying to do with 4659, somebody could say what Mr. Scott and Mr. Lukamar are doing could make our financial system riskier. Do anybody agree with that? I mean, we want to make sure that what we're doing is making our system stronger. So I don't want anybody arguing later on as we get to moving this bill that there's any risk involved. Would y'all comment on that? Anybody, Mr.
Sir, ISDA supports the legislation and believes.
Pardon me, repeat that again?
ISDA supports the legislation.
Thank you, sir.
So we're pleased to support it because it is, we think, prudent and recognizes that clearing has put IM aside, and that's a very important risk-reducing measure. And to add an SLR component on it, or not to recognize the fact that you've got risk-reducing IM associated with, just makes it more costly.
Thank you very much. Mr. Chairman, I think I'd be derelict in my duty if I not mention that I'm the ranking Democrat on the Derivatives Committee in Agriculture. And when my staff alerted me that we would be having an 11-bill legislative hearing on derivatives, I absolutely thought right then that they would give our little subcommittee in agriculture that I'm head of, where Dodd-Frank exclusively gave our subcommittee on commodities, markets, interchange, and all derivatives, a little bit of a warning and say, can you work with us on that? And I see my former chairman, Mr. Lucas, there, and I know he'd be proud of me for getting respect for our agriculture committee on this. And perhaps you might pass that along to the chairman. We hope that it wasn't a disrespect, but we work hard there, Austin Scott and I. We would have loved to have had a little part in this. Thank you, sir.
No, the gentleman's time has expired, but it's my understanding that there has been communication between our committee and the Agricultural Committee, and Dodd-Frank, as you pointed out, did put the CFTC in charge of certain aspects, but it also created a bifurcated authority under which the SEC is also a part of that, and so that is the reason.
Yeah, I don't argue any exclusivity. I just, as the ranking member, I certainly was not informed, and thought I'd bring that out. Look forward to going forward, however.
Fair enough. All right. With that, the chair recognizes the gentleman from Ohio, Mr. Davidson, for 5 minutes.
Thank you, Chairman. I really thank our witnesses, and as Mr. Scott alluded about the intersection with agriculture, that'll highlight one of the many reasons the topic of derivatives is so important to Ohio's 8th District, agriculture being very critical to our district, but manufacturing, companies like AK Steel, retail, companies like Speedway and Enon, Ohio, who are purchasing fuel, and so many others. In the insurance markets, derivatives are a massive part of global trade. They're a massive part of risk management. And before coming to Congress, I spent the past 15 years starting and growing manufacturing companies. So I know firsthand the effect Basel III has had and those international standards on the regulatory overreach that's been happening across our whole economy, particularly with the need for small companies to access capital that they need to grow. But in 2014, European regulators exempted risk-weighted assets held by European banks from the Basel-imposed capital variation adjustment requirement, also known as CVA. This exemption has provided a business advantage to European banks, European customers, and European end users at the expense of American businesses, banks, and end users. Mr. Dees, you addressed this exact concern in your opening testimony, and I wonder, in regards to the U.S. markets, what consequences you have seen as a result of the European exemption.
Congressman, thank you for that question. I'm also privileged to represent U.S. treasurers at the International Group of Treasury Associations, and our colleagues in Europe calculated that difference was about 5 basis points on an average swap. So if you take, I don't have my calculator with all the zeros in it, but if you take the $500 trillion number that the chairman mentioned of derivatives and take 10% as the estimate for end users, and then take 5 basis points of that, that's real money. And we would propose to be exempted from that and keep us in line with our European competitors.
That's terrific. I think anyone would have a hard time calling that crumbs, but I've been surprised by the use of the term lately. Do you believe this exemption only has hurt U.S. financial institutions, or does it go through the rest of the economy and affect end users?
Well, absolutely. I can tell you that we prefer to trade in general. I mean, I'm speaking now on behalf of corporate treasurers with member banks regulated by the prudential banking regulators as our swap counterparties. And I can tell you that they have to cover their costs. And to the extent they have to hold aside capital for transactions with us, they absolutely price that in. And we ultimately bear the cost as end users, and that's passed on to our customers.
Thank you for that. Mr. Benson, in their capital markets report last year, Treasury Department expressed U.S. derivatives market participants were at a disadvantage when compared to their international counterparts. Does the EU CVA exemption play a role in fostering this competitive disadvantage? And have other nations taken any action in response to this?
So I think it was 25 billion maybe, but I think the EU CVA decision was a diversion from what Basel was trying to get to having a uniform approach, but it also underscored problems in the Basel approach to CVA and more inherently. And it was a problem for the U.S. I know it was a problem for the Canadians had raised concerns about it as well, and other jurisdictions also. Basel, as I understand it, is now, I think, starting to take a look at going back and looking at CVA. So it's not helpful to have diversions within jurisdictions on global marketplaces, for number one, but even before that, is the calculation the right calculation? So we hope that this can be resolved and we can get back to a uniform standard across, globally.
So in the interim, do you feel that the CVA requirements for certain U.S. Over-the-counter derivatives could be exempted so that the U.S. would be in that level playing field?
As an issue, I know that Mr. D's group has weighed in more than ours. It's an issue that needs to be resolved for sure, one way or the other.
Mr. Dees, do you feel like Congress providing that exemption would level the playing field?
Yes, sir, that would be important, and so we fully support, the coalition does, Bill number 2 on the agenda that would achieve that for us.
Would the net effects of such an exemption be felt in sectors such as agriculture or really across the U.S. economy?
Absolutely. I was privileged to serve as treasurer of FMC Corporation, which is a leading supplier of agricultural chemicals, and I can tell you that to the extent that that company is hedging its risks with bank counterparties in the derivatives market, it bears the cost of the CVA charge they have to incur.
Thank you. My time has expired. Mr. Chairman, I yield.
Not seeing anybody on the other side of the aisle. Gentleman from North Carolina, Mr. Budd's recognized for 5 minutes.
Thank you, Mr. Chairman. And again, thank you to our witnesses for your being here today. So we have some exciting proposals that would impact the derivatives market, and we have actual legislation like Mr. Lueckemeier's bill here. 4659, which if enacted would rightfully ensure that the SLR recognizes the exposure-reducing nature of initial client margin in cleared derivative transactions. But my questions have to do with proposal number 1, which would direct the SEC and CFTC to harmonize rules overseeing the over-the-counter swaps. The different regulatory timelines and approaches under SEC and CFTC create inconsistencies and sometimes redundancies, which we can fix with this proposal. So my first question is, and this is an open question, is this. For some market participants who have to adhere to both sets of rules, how do these different approaches for many similar activities and products create compliance concerns and additional costs? Again, for any of you. We can start with you, Mr. Benson, if you like.
Again, as I point out, I mean, we're still getting the SEC rules, so they're lagging a little behind. So firms have been focusing more on their compliance with the CFTC rules. But as they're seeing where the SEC has been headed, it is raising the concerns that you would have conflicting compliance regimes that you would have to apply for different products. We do know, as I pointed out, how you define U.S. person. And again, both agencies maybe have some things that are good, some things that are not so good. So the idea, while we're still in this process of creating a mandating harmonization, driving harmonization would be a good thing.
Mr. Dees or anyone else?
If I may, the significant implication of just filing and complying with the swap data or the swap dealer rules themselves is massive. It's tens of thousands of pages, a lot of compliance back and forth, working with the staff and the agencies to develop the right compliance regimes. In fact, I don't even think the CFTC has officially and finalized the swap dealer checklist yet for anybody to be an official. They're under temporary registration. So it's a massive challenge today, and to double that with different rules with the SEC, different rules from the CFTC, different guidance you may receive from the staff will just make that operation that much more difficult. So I think a safe harbor, when you've complied eventually with the SEC or the CFTC rules, either one, then you've met that mandate. Then you think about some of the other capital requirements and other requirements that will pass on as a result of that. From a practical standpoint, it's an operational challenge of enormous consequence.
Thank you. Mr. Green?
Just a couple of thoughts. One is that these are very different markets. Credit default swaps look to bonds, foreign exchange look to currencies, commodities are very different from interest rates, et cetera, and total return swaps are in the equities market. So there are legitimate differences that can and should emerge based on these different markets. Everybody wants as much similarity as possible. I do think we're seeing that, but one of the U.S. person definition, frankly, the SEC has taken a weaker approach in part due to massive lobbying to try to dial back jurisdiction towards being only the U.S., whereas the CFTC took an approach as mandated in Dodd-Frank that said, if the risk is going to come back to the U.S., we're going to capture that. So I think there's tensions and things going on that we need to think about.
Thank you, Mr. Green. I want to go ahead and jump to the second question while we have some time. Besides this proposal, which I support, are there any other approaches to this body that they should consider, such as a regulatory safe harbor?
Yeah, a safe harbor would be a good idea. And I think the other thing to keep in mind is where we are today, versus where we were a year ago or certainly 8 years ago, is a lot has already been done. So I would caution, mandating starting all over again. Let's work within, let's start with the framework we're in, and let's figure out how we can make it work, and a safe harbor is a good example of that.
I think to Mr. Green's point, if you do believe that the SEC should have different rules, a safe harbor works nicely, because then it respects the SEC's differences to whatever extent there are, and then you can say, all right, if you've complied with one, you've complied with the other. A safe harbor also protects this committee's jurisdiction. And when you think about as Mr. Green pointed out, the difficulty around products, the difficulty around jurisdictions, there's no way to neatly divide this up. And to protect everybody's current jurisdiction, as Mr. Scott pointed out, it's important the agriculture have its oversight. This is the easiest way, in our opinion, to make sure that everybody still controls their piece of the pie.
Thank you for that. And I want to go ahead and yield back since I'm out of time.
Gentleman's time has expired. With that, we welcome our guest, gentleman from Oklahoma, Mr. Lucas, for 5 minutes.
Thank you, Mr. Chairman, and I appreciate the opportunity to join this subcommittee today. Not necessarily being a member of the subcommittee, but a member of the full committee, and as was noted by my colleague off the Ag Committee and fellow member here, Mr. Scott, an old Ag Committee chairman and ranking member at the time Dodd-Frank was put together, I'm very sensitive about this issue, and in fact, it's a topic that matters to my farmers, my ranchers, all my end users in the district who use these derivative products to hedge their positions in the market. And I would note, as has been discussed much by a variety of members, I'm also particularly pleased to note the two proposals under consideration today, and very happy to be one of the original co-sponsors of Mr. Luptemeyer's Bill 4659. To support the offsetting the initial margin for SLR calculations. And the second draft is a proposal regarding margin requirements for interaffiliated transactions, which mirrors my amendments to the CFTC reauthorization bill that was passed out of the full House last year. But first, turning to Mr. O'Malley and the SLR issue, this issue is not immediately obvious to people that don't interact a lot with derivatives markets. but could you briefly explain the rules that ensure that posted customer margin cannot be used to fund a bank's own operation? Let's get to the core of the issue here.
Yeah, that's an important point, because that just shows that the IM, or the initial margin, is reserved and protected, not on the bank's balance sheet. It is with a clearinghouse, for example, or it could be possibly with a U.S. Federal Reserve account where they've put the cash as well. So these are in very safe and secure spots and are truly reserved for risk reduction. They are also the property of the customer.
So one more time, let's make it very clear. So there's no real threat that money can be misappropriated by a bank when it's placed in one of these accounts.
Correct. In these secured third-party accounts, there's
Because that's one of the concerns of my colleagues, is that this money that's in secured third-party accounts might be manipulated by the banking institution. But that's not going to happen, okay? So let's assume this bill were to be passed into law, and CFTC Chairman Giancarlo has estimated that enacting this simple change would reduce leverage exposure by a mere 0.22% nationwide. That's about 1/4 percentage point nationwide. Do you have any sense as to how much clearing activity would be increased by such a bill?
We do not, sir, offhand.
But it's a fair statement to say there would indeed be an increase.
Well, it certainly reduces the cost of not paying two insurance protection items. One, IM, which is significant, and then the other is any charge you've had to pay for dealing with a bank that will charge you an SLR.
With, as Mr. Giancarlo noted, an increase of 0.22 of a percentage point nationwide in exposure. That's a pretty cost-effective balance out, I would think. Mr. Benson, turning to the inter-affiliate margin requirements, could you give us some reasons why affiliates might want to enter into these transactions? And we're a body where you need to reinforce the important points.
So the banks will enter into inter-affiliate transactions when they've got an outbound transaction, and then they'll do swaps to better manage and mitigate their risk as an organization. And so they're not taking on more risk. They've already collected margin where they need to. It's really, in effect, collecting margin again. And that ends up trapping, and to your point, that you were just making with respect to central clearing and the SLR, that ends up trapping assets which are not actually available to the bank in that instance as well. In fact, the prudential regulators who require this, which is different than the CFTC, different than Japan and Europe and other Basel entities, the prudential regulators do not count this margin in the bank's resolution plans. It is not viewed as available for single point of entry in the resolution plans. So in effect, it's not really adding value from a safety and soundness or a systemic aspect, but it is trapping capital that could be allocated elsewhere.
Which is a cost to the economy as a whole when you have dead weight out there.
Yes, sir.
Mr. Chairman, and a final observation, I would simply note to my colleagues, a handful of us only anymore, it seems like we're here for the Dodd-Frank process and all the things we went through in that bill. I would note to my colleagues that the document that dealt with derivatives that came out of the Ag Committee was done in a very bipartisan way 9 years ago. And the work that was done in this committee was done in a relatively bipartisan way. It's when we got to conference that the bill that came out of there was not a bipartisan document. I always note to my friends, when the primary authors of legislation retire shortly after it's signed into law, that's an indication. Yield back, Mr. Chairman.
That's an interesting observation. So with that, we would like to welcome our other guest, the Chairman of the Financial Institutions, Mr. Lukemeyer, for 5 minutes.
Thank you, Chairman Zinga. Appreciate the opportunity to be in your committee this afternoon and listen to some of the testimony and the questions. As I've been listening here, they've been discussing HR 4659 and have thoroughly discussed it in my mind, a lot of the ins and outs, and I don't know that I got a whole lot of questions left here, but let me just thank Congressman Scott for his hard work on the bill, and I know Congressman Lucas, who just asked some questions, did a very good job of framing some of the concerns that we had, that we tried to address with supplemental leverage ratios here. So let me just ask a couple quick questions here with regards to, I'm a firm believer the banks need to hold adequate capital to protect themselves and their customers and the financial system. This is one thing that both Republicans and Democrats agreed upon coming out of the financial crisis, as Chairman Lucas just indicated. With respect to supplemental leverage ratio, do you believe the current treatment of client margin is appropriate? Mr. O'Malley?
We do.
Very good. You want to elaborate more than just yes?
Yes. This is protective. This has gone back years and years. In,
Right.
You know, so many things around client protection of margin, and goes back all the way to the early futures markets. And we built those solutions on those, and those have been robust. They have not changed. They're protective. They're resilient. We've found with different FCM failures that there's a way to protect the client margin here. And it's very important as we think about what we're going to do with raising the standards around CCPs going forward, because the resolution and recovery tools around CCPs we think can be increased. You have better protection around protecting IM and customer margin that has been given to a CCP. We want to make sure that the waterfall events do protect that customer money going forward. It is the foundation of this very safe system.
Perfect. With respect to the impact of HR 4659, the CFTC has calculated that an offset for initial client margin will result in less than 1% decrease in overall capital reserves. Do you agree with the financial system? Do you agree that the financial system could withstand a capital reduction to less than a penny on a dollar in exchange for both significantly reduced costs on agriculture producers and encouraging more clearing in the derivatives market?
We do. We do believe that it could withstand that, and the system will be safe.
Anybody else?
I mean, the supplementary leverage ratio is based on the idea that we want a risk-neutral way of evaluating the capital, the equity that's in the system. And the more you start adjusting things based on how people view the riskiness or the usability, et cetera, of a particular asset, the less value it is overall of being risk blind. And it's important, I think, to remember that this is the supplementary leverage ratio is attempting to calculate a broader overall exposure. The margin or even the capital against the swap is only a portion of the overall risk that could come back to the firm. The firm stands in with a full guarantee to the counterparty, and so the SLR attempts to calculate that. And as folks like Shilubert and other respected regulators, Tom Honig at the FDIC, have noted that it's the simplicity of the leverage ratio that gives it its value, and they've got to try to retain that as much as possible.
Mr. Benson, you got a comment on that? Look, I could see you weren't or Mr. Benson?
Oh, sure. First of all, again, it contravenes official policy going back to the Obama administration to drive more of the swap business to central clearing. And even not just Chairman Giancarlo, but Chairman Massid had come out and said that this should be changed. The second thing is the SLR, which is gold-plated in the U.S., we've had a leverage ratio in the U.S. since the Great Depression. We took it from 3% to 5% and 6%. And it has become the binding constraint on top of what is an extremely robust capital regime that's been put in place since the financial crisis, which can exceed to high double digits for many firms. So the idea of making this one change that is counterintuitive to what the policy is to drive, really the benefits or the cost in this instance far outweigh the benefits as what policy has been.
You had a comment you were going to make, sir?
Well, sir, just speaking as a corporate treasurer, I can tell you that if ultimately the initial margin and capital through CVA and other requirements are intended to offset risk, and yet if initial margin is not calculated in the determination of risk for capital purposes, it seems to be out of sync with the economic realities, and ultimately that will get us off track.
Appreciate your comments. I see I'm out of time. I'll yield back. Thank you, Mr. Chairman, for your indulgence today.
No problem. Gentleman's time has expired. With that, Mr. Hollingsworth from Indiana is recognized for 5 minutes.
Well, if nobody's told you yet, happy Valentine's Day. So I actually live in the very southern part of my district in Indiana, and I live just literally 2 or 3 miles from the Kentucky border. And sometimes I run into businesses based in Indiana, right, that say, I have a location in Kentucky and a location in Indiana, and I'm literally required to do something in Indiana, and I am barred from doing that same thing in Kentucky. And they're trying to work across those two jurisdictions. Now, that's a really small problem for a lot of small businesses, but it can be a really big problem. And I think it was addressed in the Treasury report for large multinationals trying to comply with U.S. rules, but might find themselves in a situation where non-U.S. jurisdictions bar them from certain activities. So this is coming to Mr. Benson and Mr. Omaya. I wanted to really address this. I think both of you alluded to this in your testimony earlier, but I want to draw your attention to pages 133, 135 of the Treasury report. Quote, market participants have raised concerns with aspects of the SEC's cross-border rules and have highlighted those that conflict with privacy, blocking, and secrecy laws in non-U.S. jurisdictions. So companies here trying to comply with rules here, but maybe see cross-currents of rules elsewhere, preventing them from full compliance here. And I think this has a long history of us trying to work these things out, right? Task force getting together, signing MOUs, forbearance, et cetera. I guess I really wanted to get at, what do you think that those trying to comply with U.S. derivatives rules, what suggestions of how U.S. regulators, including the SEC and the CFTC, should work to help ensure there's harmony between these two, or ensure there's opportunities for cross-national companies to be able to operate in both jurisdictions, meet the rules of both jurisdictions? Are there any suggestions you'd have for the SEC or CFTC on how we could best work through that process as quickly as possible to ensure that these companies that want to do the right thing can quickly do the right thing for both the jurisdictions they operate in?
So I guess I'll start. I think this is an issue that it's hard to believe why this can't be worked out. And I think if you read other parts of the Treasury report, particularly the first Treasury report, it makes a very important point that is indicative of the U.S. Financial markets, because we have a very open market system here. Right. We have both U.S. and non-U.S. domiciled firms that invest in our markets and provide capital, credit, and liquidity to our markets to the betterment of the country as a whole. And one of the things it points out is that non-U.S. domiciled financial institutions provide a tremendous amount of credit and capital to the U.S. markets, yes, including to areas like Indiana in the agricultural space and elsewhere. So that's important, and we should value that. The problem is where we have rules that conflict, and we have this inbound also from other jurisdictions, that sometimes in the U.S., rules that conflict with a domestic rule that could preclude an entity from actually providing the services in the U.S., and that would create a cost to the system here. So to us, it seems in the case where a European-based swap dealer cannot comply with the rule as defined by the SEC, and therefore can't be a registered swap dealer, doesn't seem to, there's got to be a way to work through that.
It doesn't benefit us.
It doesn't benefit us.
I mean, for those that might say, we want to keep foreign firms out, that is not true of the financial services industry. It's not true generally. We want to make sure that everybody participates.
It would be to a disadvantage of the U.S.
That's exactly right. Well said.
There are a number of examples, and I know each of the chairmen of the respective agencies have worked very hard to build the international bridges, and I'd have to say that the relationship among this administration and with internationally has been quite strong. Good. Time has passed since some of the earlier rules. The exporting of U.S. regulation has kind of dissipated a little bit, and the conversation is probably moved on, but there are always going to be these little issues where there's a misunderstanding, or you just simply can't deliver the rules. There are plenty of data rules globally that privacy functions prevent from entities from reporting. Asia in particular has a number of these things. But to Ken's point, you certainly don't want to put the U.S. at a disadvantage in terms of attracting capital or business.
Yeah. I'm a big believer that, frankly, the more participants we have, more varied participants that we have, the better and stronger, more resilient the ecosystem is overall, that truly that resiliency is a more emergent quality than a dictated quality. And so we need to welcome foreign firms operating here. Rising tide lifts all boats, but we've got to figure out a way to get through some of these gaps and make sure that, frankly, across jurisdictions, they can comply with both sides at the same time to better empower them, which ultimately empower better Americans better, and that's what I'm really excited about. And with that, Mr. Chairman, I'll yield back.
Gentleman yields back. Well, I'd like to thank our witnesses for their testimony today. I think this was very illuminating and helpful as we're having this. Without objection, I would like to submit the following statements for the record. First, a statement from Richard Baker, President and CEO of the Managed Funds Association, without objection. and a letter of support from FIA, Commodity Markets Council, CME Group, and the Intercontinental Exchange, without objection. And also without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will then be forwarded to our witnesses for their responses. And I ask that our witnesses please respond as promptly as you are able to do so. And without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. So once again, I would appreciate your time and expertise in this very complicated space, and we look forward to continuing this conversation. With that, this hearing is adjourned.